We've got a really fascinating set of sources you sent over detailing this constitutional showdown that's happening, well, right now on the West Coast.
Yeah, it's all about presidential power, state sovereignty, and, the National Guard.
And it's not just politics, is it? It feels like a real high-stakes legal chess match playing out in real time.
Oh, absolutely. Some remarkable legal gymnastics, really. We're looking at a situation where the Trump administration basically did an end run around a federal court order
How so?
by deploying troops from California into Oregon right after a judge blocked them using Oregon's own National Guard.
Okay, so our mission today for you listening is to give you that shortcut, to really unpack how the federal government pulled this off, moving federalized California National Guard troops, the CNG, into Portland almost overnight.
And what this whole thing says about the 10th Amendment, that line between state police powers and federal authority.
Right. And the hook here, the thing that grabs you, is just how fast and, frankly, how bold this deployment was.
Yeah, by Sunday morning, October 5th, you had at least 200 federalized CNG members hitting the ground in Portland.
And this was just hours after a U.S. district judge issued a temporary restraining order, a TRO, saying, no, you can't deploy the Oregon National Guard.
Exactly, a direct countermove.
So let's start with that first barrier, the one the administration was trying to get around. The ruling came from U.S. District Judge Corinne Immergut.
hmm And interestingly, she was actually appointed by President Trump during his first term.
That is interesting. So what was her reasoning?
Well, her ruling on Saturday was quite specific. She issued the TRO, set to expire October 18th, and she basically said, look, the protests in Portland are relatively small, localized.
Not exactly an insurrection.
Right, not an insurrection or the kind of massive civil unrest that justifies federalizing forces. And she argued that allowing the deployment could cause irreparable harm to Oregon's state sovereignty.
Okay, and she backed that up with some strong language.
She did. She cited a long-standing and foundational tradition of resistance to government overreach. Pretty direct.
Wow. Okay, using resistance to government overreach to block the administration. That's a statement. But the White House didn't just appeal.
Well, they did file a motion for an emergency pause with the Ninth Circuit, the appeals court.
Yeah.
But their immediate move, the end run you mentioned, was different.
They shifted gears.
Completely.
Yeah.
They just retasked troops they already controlled federally, the California Guard members.
Ah, okay, so these weren't Oregon troops under the governor's command.
No, these were California Guard members who had already been federalized earlier for duty in Los Angeles. Chief Pentagon spokesman Sean Parnell confirmed it, about 200 federalized CNG moving from L.A. to Portland.
And their stated mission.
To support federal personnel already there, like ICE agents and others.
Okay, but to really get this end run, we have to talk about the different ways the Guard can operate, legally speaking. This federal versus state thing is crucial, right?
It's the absolute core of the dispute. It's not just politics, it's embedded in U.S. law. When a governor calls up the Guard for state duty, think disaster relief, local unrest, they operate under Title 32 of the U.S. Code.
And the governor stays in charge.
Exactly. But when the president federalizes the Guard, using specific authorities like the Insurrection Act or others, their status flips to Title 10.
Title 10, that's the key here.
That's the key. Under Title 10, they are effectively federal military forces. They operate under the president's command chain, not the governor's.
So when those California Guard members were federalized for L.A.,
their command shifted. They went from Governor Newsom's control to President Trump's control. They became Title 10 forces.
and once they were Title 10,
The administration believed it had the lawful authority to send them anywhere in the country needed to protect federal assets or enforce federal law, regardless of what the governor of the destination state wanted.
Okay, so put yourself in Governor Kotek's shoes in Oregon. You just want a court order blocking the feds from using your Guard. Then you wake up, and 200 California Guard members, now essentially federal troops, are landing in your state anyway against your wishes.
It looks like a loophole from the state's perspective, a way to completely bypass the court's initial intent.
But doesn't moving them from LA to Portland kind of weaken the administration's own argument that those troops were desperately needed in LA in the first place?
That's exactly the point the Attorney General from California and Oregon jumped on immediately.
Okay, so how did the states react, Governor Kotek?
Well, she confirmed the arrivals 101 CNG members initially, Saturday night, more expected. And she did not hold back, called it an intentional attempt to circumvent the judge's ruling.
Yeah, I saw her quotes. Pretty strong. There is no insurrection in Portland, no threat to national security.
And then she added, Oregon is our home, not a military target, really framing it as an invasion of sorts.
What about California? Governor Newsom, these were technically his state's Guard members originally.
He backed Oregon up immediately, vowed to sue the Trump administration. He called the deployment a breathtaking abuse of the law and power,
Strong words.
and accused the president of using the military as a political weapon against American citizens.
So a unified front from the two states. And they followed up with legal action.
They did, very quickly. Oregon AG Dan Rayfield and California AG Rob Bonta filed a second TRO request.
Aimed specifically at these California troops now.
Exactly. Blocking the deployment of the federalized CNG within Portland.
And their core argument in this second TRO.
Irreparable harm, again. But crucially, they argued it violates state sovereignty and the police powers reserved to the states under the 10th Amendment of the U.S. Constitution.
Okay, let's dig into that 10th Amendment piece. Why is using federalized troops for something like protests or civil unrest seen as stepping on the 10th Amendment?
Well, the 10th Amendment says any powers not specifically given to the federal government are reserved for the states. One of the most fundamental reserved powers is the police power.
Meaning the state's right to maintain order, public safety, within its own borders.
Precisely. So when the federal government, using federalized troops, comes in to do what looks like a domestic policing job, especially against the state's will, the states argue that's the federal government overstepping its constitutional bounds.
And A.G. Bonta made that point about the troops supposedly needed in L.A.
Yes, he specifically highlighted that contradiction. How could they be urgently needed in L.A. 1 minute and then sent wholesale to Oregon the next without hesitation? He argued it showed the motive wasn't really about need, but about federal intervention itself.
Okay, but the administration isn't just rolling over. They're fighting the original Immerget ruling in the Ninth Circuit. What's their counter-argument?
Their argument is also powerful, constitutionally speaking. It centers on presidential authority. White House spokesperson Abigail Jackson said President Trump simply exercised his lawful authority to protect federal assets and personnel in Portland. And in their motion to the Ninth Circuit, they argued Judge Immerget impermissibly second-guessed the president's military judgments.
So they're saying, basically, once the president decides there's a military need, especially for Title X troops, courts and governors need to stay out of it.
That's the essence of it. They're citing, nearly 2 centuries of Supreme Court precedent suggesting that these kinds of military judgment calls belong solely to the president as commander-in-chief.
Not to a local governor or a federal district judge issuing a TRO.
Exactly. From the White House view, these are federal troops protecting federal property and personnel, and states can't legally interfere with that federal mission, even if it's happening domestically.
We also need to see this Oregon situation in a broader context, right? This isn't the first time the administration has used federal forces this way.
Not at all. It fits a pattern. We've seen deployments of the Guard, even active duty Marines, in places like D.C. and Los Angeles before.
And Chicago, too. Wasn't there something there?
Yes. In Chicago, 300 Illinois National Guard troops were federalized and deployed after Governor J.B. Pritzker initially refused an ultimatum to deploy them under state command.
So this move, using troops from a different state under Title X after being blocked locally, feels like the next step, maybe the most aggressive use of that authority yet.
It certainly seems that way, pushing the legal envelope after hitting a judicial roadblock.
Okay, so let's try to synthesize this for everyone listening. It's messy. You've got this really unusual multi-front legal battle.
Definitely. You have 2 states, Oregon and California, suing the federal government together over troops from California being used in Oregon.
Their argument, it violates the 10th Amendment, state police powers.
Right. And this is happening at the same time the administration is appealing a totally separate ruling that blocked them using Oregon's own Guard, based on sovereignty grounds.
So this whole fight really gets to the heart of defining the limits of presidential power in domestic emergencies.
It does. It's not just about who controls soldiers on the ground. It's about whether the president's Title X authority basically trumps the 10th Amendment when those soldiers are used for, local civil issues against the state's wishes.
And the language from the state's breathtaking abuse, political weapon, not a military target. That's not just political rhetoric, is it? It feels aimed squarely at the court's concerns about military overreach.
Absolutely. That language is designed to resonate legally, especially thinking back to Judge Immergut, citing that tradition of resistance to government overreach.
Which brings us, I think, to a final thought for you, the listener, to consider.
Yeah, think about this. Judge Immergut initially found the situation didn't justify military intervention. The states insist Portland isn't a military target. Now the administration has used this Title X mechanism to bring in troops from another state anyway.
So the question is, how will the appeals court weigh that? Does the technical legal status of the troops under Title X completely override the state's 10th Amendment concerns and that historical resistance to federal overreach, especially when it's about localized domestic civil affairs?
Where that balance lands could really redefine the boundaries of presidential power inside the U.S. for years to come.